So this again is on the Canada Labor Code, and the issue we're discussing here is that a person who is a manager is not allowed to use the remedy under the Canada Labor Code. But there have been many cases defining what exactly a manager is and how the court will look to determine if the person is a manager. Again, if the person is a manager, they cannot use the remedy. However, the cases interpreting the word manager have been very restrictive in favor of the employee. There are many cases in which a person has held the title as a manager and has been allowed to use the Canada Labor Code remedy. For example, there are people that have been had held the title of bank branch manager and allowed to use the remedy. So let me just review some of the tests involved to determine if the person is a manager or not. I got to look at my notes here, so excuse me. The person has to have the power to act and perform duties independently and is part of management, and the prime responsibility is to manage. So it's not a situation where, from Fridays from 12 to 4, I'm the manager of the branch. It has to be a complete responsibility throughout the working relationship. There must be evidence of the ability to fire and discipline, and the person must be responsible for the company's operations and must be accountable for management functions. There must be sufficient evidence of independent decision-making authority, although not absolute, must still have that degree of ability to make decisions on his or her own. So these are some of the cases dealing with the definition of manager. The general interpretation, again, is that it has to be defined very narrowly in favor of the employee. So just because someone looks like the word manager is in their title does not exclude the remedy. The court or the adjudicator will take a purposeful look at the responsibilities to see if there is independent managerial authority. So beware of this, and if you're considering a complaint under the Canada Labor Code, it's very important. It's a powerful remedy, again, a ticking time clock, unlike wrongful dismissal cases. So there's a lost income claim, again, till the date of the hearing or final disposition of the case. It can be considerable, so beware and be smart.